Good evening. I am your state representative, Candice in Newell, House District 99. I know most of you all are exhausted from all of the changes that we're hearing happening on the federal level. But this is not the time for us to get complacent. We cannot go back. In March, we will have 4 constitutional amendments on the ballot. None of these constitutional amendments are good for our state. They are all regressive financially as well as for the civic progress that this state has made. We're going to go right on into these amendments, starting with proposed amendments number 1, Act 2 from the 2024 third extraordinary session, proposing to amend Article 5, Section 5B, 15A, and 16A of the Constitution of Louisiana relative to the jurisdiction of the courts and the disciplinary proceedings over attorneys from out of state, as well as authorizing the legislature to create courts of limited or specialized jurisdiction. The ballot language reads, do you support an amendment granting the Louisiana Supreme Court jurisdiction to discipline out-of-state lawyers for unethical legal practices in the state of Louisiana, and to grant the legislature the authority to establish trial courts of limited and specialized jurisdiction? The Louisiana Supreme Court already has the jurisdiction to discipline out-of-state attorneys, a process which was created by the Louisiana Attorney Disciplinary Board. The rules are Supreme Court Rule 19, Section 13 and 14, and Louisiana Disciplinary Board 19, Section 6A. These procedures have been in place since 2004. This constitutional amendment would also allow the legislature to create specialty courts outside of the existing jurisdictional districts. There are already several specialty courts, mainly drug courts and veteran courts, and the main court that is being considered is a business court. The Louisiana legislature has been trying to eliminate judicial seats, particularly in New Orleans, Baton Rouge, and Monroe, for the past several years. Louisiana has the most elected black judges per capita in the country. What will happen is that the court cases which meet this specialized jurisdiction subject matter of the specialty courts will be moved from the state court and go to these specialty courts. This will allow for courts to be reduced and judges to be removed because the court dockets will not be as robust as they currently are. This will not only negatively impact New Orleans, but also rural courts where judges already have light dockets due to the amount of people that live in those districts. I questioned the author of the bill to define what a business court is, what other specialties these courts will address, where would the physical location of these courts be, how would the cases that have multiple subject matters be addressed. For instance, if there's a divorce case that has a business issue, would those two issues be bifurcated? Would they be heard simultaneously? Would the couple have to hire an additional attorney to handle the business issue to go to the specialty courts? Would these judges be appointed as opposed to being elected by the citizens of this state? Who would make the appointments of these judges? And considering the separation of the 3 branches of government, who would have oversight of these specialty courts created by the legislature? And would this creation remove the power of the Supreme Court to discipline these judges and the attorneys who practice in these specialty courts? I also asked if the consideration is to have a regional court, and how will the jurisdictional venue issues be determined? Do you want an issue involving Orleans residents being heard in a court in St. Bernard, Jefferson, or Claiborne Parish, where the jurors could be chosen from residents in those parishes? I think not. The author did not address any of these concerns, and he did not give any definitive answers. His constant comment was, we just want the opportunity to create these courts. We must also consider that several corporations have already moved their businesses to Delaware following a dispute that Elon Musk had in the court in Delaware, where Tesla wanted to offer him a $345 million compensation package, whereas his ask was a $55 billion compensation package. And the judges in Delaware constantly struck down his requests as being excessive and overburdensome. So he moved SpaceX to Texas, and has also have other companies have moved their corporations from Delaware to Texas and Nevada. Proposed Amendment Number 2, Act 1 of the 2024 Third Extraordinary Session, proposing to revise Article 7 of the Constitution of Louisiana relative to revenue and finance, and to provide for the respect of the power of taxation, including limitations thereon. The ballot language reads, do you support an amendment to revise Article 7 of the Constitution of Louisiana, including revisions to lower the maximum rate of income tax, increase income tax deductions for citizens over 65, provide for a government growth limit, modify operation of certain constitutional funds, provide for property tax exemptions, retaining the homestead exemption and exemption for religious organizations, provide a permanent teacher salary increase by requiring a surplus payment to teacher retirement debt, and make other modifications. This was a 115-page constitutional amendment, which has been condensed to only 6 lines, only highlighting the positive. But let's tackle the issues that will be placed on the ballot. Number 1, lowering the maximum rate of income tax. The individual income tax would be reduced not to exceed a maximum of 3.7%, which is currently 4.75%. During the third special session of the legislature, we implemented a flat 3% personal income tax rate, meaning that the wealthiest citizens can see upwards of a 1.25 reduction, and the working class citizen would only see a 0.25 reduction in their personal income tax. The legislature also abolished corporate sales tax while enacting an incremental sales tax increase, capping at 10%, which would set Louisiana as having the highest sales tax in the country. Only the wealthiest people and corporations would disproportionately benefit from this change in the tax structure. Our governor and some of my legislative colleagues believe that these wealthy people and corporations will use their savings to invest in the state and grow the economy. Some of you do remember the trickle-down economics from the Reagan era. And you also remember that this trickle-down economics did not work then. Number 2 is we will increase income tax deductions for citizens over the age of 65. The double standard income would start in the 2026 tax year. Anyone over 65 who pays taxes will have a standard deduction of $12,500 for singles and $25,000 for married filing separately or filing head of household. This standard deduction is only good for those people who are depending upon their tax bracket and other deductions they qualify for, such as mortgage interest deductions. Number 3 is the government growth limit. The government growth limit would maintain our current spending limit and restrict spending of state general funds, restrictions that the expenditure of tax and fee revenue does not currently have. This is annual increases in state spending tied to population growth and inflation. The government growth limit would be set annually and could be spent only on one-time projects, not recurring expenditures, which could grow the state government spending. If one-time expenditures exceeded the growth limit, it would need to pass with a 2/3 vote of both the House and the Senate. Additionally, these restraints would also limit the legislature's ability to address state needs as they arise. For example, If costs grow for the Department of Justice because we are increasing the prison populations, we will be forced to cut another department's budget because the limit would not reflect the availability of funds. Also, these calculations for the government growth limit does not address the inevitable population decrease caused by hurricanes or other disasters. Any extra money in the budget beyond the government growth limit would have to go towards one-time projects like roads and bridges instead of going to ongoing or special needs projects. So that means no additional money for individual districts to repair lights in the park, to help a fraternity or sorority with a special after-school feeding programs or outreach programs or community activities like festivals or parades. It will create a spending limit on essential services like education, healthcare, and ongoing programs and projects. This past year, we reduced the investment in the Head Start program and other after-school programs, senior citizen day facilities, and there's a cut proposed for an outpatient memory care facility. Currently, Louisiana has a constitutionally set spending cap called the expenditure limit, which is set annually and based on changes in the yearly personal income in Louisiana. This slows the legislature from spending lots of money during good times, so there's no financial fallout when times are bad. The Constitution allows us for us to set the expenditure limit by a 2/3 vote of both House and the Senate. This has been done 3 times in legislative history. The last time was in 2023. Number 4, modified operation of certain constitutional funds. Louisiana has 2 budgets most have heard of before: the Budget Stabilization Fund, known as the Rainy Day Fund, and the Revenue Stabilization Trust Fund. The Revenue Stabilization Trust Fund has $2.73 billion and is used to reduce the state's dependence on volatile taxes such as taxes generated by tourism and oil and gas prices. The Rainy Day Fund has $1.07 billion, and it is used if the state faces a budget deficit and sustain state operations. For example, during COVID, before federal funding was assisted, Louisiana was able to keep government operations going. No more than 1/3 of the balance can be spent in a 2-year period. So in the case of a federally declared disasters like the 2016 flood in Baton Rouge, the Rainy Day Fund was used, but the spending could not exceed the state's actual costs associated with the disaster. With combining these funds, we would no longer have the flexibility or the capability to assist in these needs. Most of the money deposited into this fund comes from corporate tax collections and oil and gas production revenue. Combining the 2 funds and reducing the deposit amounts would lessen state reserves by $1 billion instead of building safeguards for the state against financial instability and market downturns. For example, the drill baby drill would be a financial downturn for Louisiana because excess drilling would make it cheaper for Exxon and Shell to purchase gas from other producers instead of refining it themselves, and therefore there would be a cut to hundreds of jobs across this state. Removing the requirement that revenue collections go into savings accounts would allow the governor and legislators the ability to use the money on ongoing projects, which may prove to be unsustainable due to the constant increase on materials and services and the uncertainty of revenue sources. Number 5, provide for property tax exemptions, retaining the homestead exemption and exemption for religious organizations. This amendment does not affect the $75,000 homestead exemption or the exemption of taxes on prescriptions, groceries, and residential utilities. This amendment would remove the limit on the amount of money parishes can receive from severance tax, a tax which is on natural gas resources like oil and gas, allowing more of that money to go to local governments. This would increase the payments to parishes, but it would lessen the amount of money that the state has to spend from the general funds. For example, if this were in place in the 2024 budget year, payments to parishes would have increased by $75 million, and the state general funds would have reduced by $75 million. It will remove the guaranteed maximum tax rate on cigarettes and vehicle registration fee, giving lawmakers the power to decide how much to tax or how much the fee would be, or if there would be a tax or fee existing at all. Also, each individual parish would have the option of repealing or canceling property tax on business inventory and take most property tax exemptions out of the Constitution and put the fate of these exemptions in the hands of legislators. This amendment also impacts liens on homes, making it easier for your property or your home to be foreclosed and for you to lose that property. This amendment would also impose a cap on annual spending and make it harder to create tax breaks and actually attract businesses that would invest in our state. It would also take away tax exemptions from nonprofit organizations, social service groups, fraternal organizations, and non-religious schools, meaning these organizations which have enjoyed a tax benefit would no longer have that benefit and would have to start paying property tax. Only religious institutions would remain tax exempt. Any new tax exemption, exclusion, deduction, credit, rebate, or any increase in the amount of tax deduction, credit, or rebate would only require a 2/3 vote of the legislature. It would no longer be put to a vote of the people. Number 6, provide a permanent teacher salary increase by requiring a surplus payment to teacher retirement debt and make other modification. The language indicates that there will be a permanent teacher salary increase. However, there is no salary increase. 3 education trust funds, the Louisiana Educational Quality Trust Fund, Louisiana Quality Education Support Fund, and Education Excellence Fund would be dissolved, and the funds would be used to pay off some of the retirement debt, which the state already has a plan and has already been paying off that debt. The K-12 system would have to use their savings to fund the current teacher stipend. The stipend that the teachers have been receiving for the past few years will be permanent. Teachers will not be paid more than what they're currently receiving, and some teachers, particularly those in New Orleans, could receive less than what they're receiving now. The savings from the retirement payment will not be enough to cover the full cost of the pay raisings, and it will not cover costs for charter schools who do not participate in the Teachers Retirement System of Louisiana, TRSL. If a school system can't fully cover the raises, like in Orleans Parish, the school system isn't required to until the legislature agrees to increase the annual public school funds formula to pay for the salary increase. Also, colleges and universities are urged to use the savings from their contribution to TRSL to fund current programs, and the state will cover the deficit. However, the promise the state has made to cover any deficit realized by the K-12 system or the colleges is not in legislation. It was a verbal promise. The promise to cover deficits were also given to parishes which opt to halt collection of corporate franchise taxes. However, there is no clear calculation or explanation as to where the money is coming from, aside from increasing the sales taxes and taxes on the middle class and working poor. Only highlighting the positives of a convoluted 115-page tax restructure that was rushed through a 2-week process is not good government. Furthermore, the state cannot afford to cover these budget gaps, and we are not allowed to operate in a deficit like the federal government. Side note that this is an ongoing lawsuit challenging the language of this constitutional amendment and how misleading it is to the public. This is an issue that I pointed out during the House floor debates. Proposed Amendment Number 3, Act 3 of the 2024 Third Extraordinary Session, proposing to amend Article 5, Section 19 of the Constitutional of the Constitution of Louisiana relative to special juvenile proceedings to provide relative to crimes committed by juveniles, to allow adult prosecution for certain felony offenses specified by the legislature, and to specify an election for submission of the proposition to electors and provide a ballot proposition. The ballot language reads, do you support an amendment to provide the legislature the authority to determine which felony crimes, when committed by a person under the age of 17, may be transferred for criminal prosecution as an adult? Currently, the Louisiana State Constitution does not allow for special juvenile procedures to apply to juveniles arrested for having committed first, a second-degree murder, manslaughter, aggravated rape, armed robbery, aggravated burglary, aggravated kidnapping, attempted first-degree murder, attempted second-degree murder, forcible rape, simple rape, second-degree kidnapping, a second or subsequent aggravated battery, a second or subsequent aggravated burglary, a second or subsequent offense of burglary of an inhabited dwelling, or a second or subsequent felony grade violation of Part 10 or 10B of Chapter 4 of Title 40 of the Louisiana Revised Statute of 1950, which involves the manufacture, distribution, or possession with intent to distribute controlled dangerous substances. According to our Constitution, the crimes that I just listed already require that a juvenile who commits these crimes be prosecuted as an adult. However, if this amendment passes, all of those crimes will be removed from the state constitution, and the legislature will be allowed to decide which crimes a juvenile can be charged as an adult for without a constitutional amendment and without a vote of the people. Some legislators want to include sex trafficking, carjacking, home invasion, drive-by shooting, and a distribution of fentanyl to this list of felonies. However, those crimes are already covered by the list that is currently in the state's constitution. Felony theft is stealing of anything over $1,000. So if a child takes someone's iPhone at school, he would be in prison for a max of 5 years or have a max of a $3,000 fine. If the child steals the phone from a store and in an attempt to escape knocks over a store employee, that is considered an assault and commission of a felony. 15 days of whatever sentence imposed must be served without the benefit of probation or parole. These children will not be tried in juvenile court, nor will they serve their time in a juvenile detention center. They will go to OPP. Their case will be heard at Tulane and Broad, or whatever facility has room to take them. Most sheriffs in this state do not have the space to house juvenile offenders because there are still federal protections in place to keep children out of sight and sound of adult inmates. The records of juveniles will no longer be sealed because they will be processed in the adult criminal justice system. With a criminal record, students cannot get financial aid. Some banks will not offer personal loans, and obtaining housing will be nearly impossible. Proposed Amendment Number 4, Act 4 of the 2024 Third Extraordinary Session, proposing to amend Article 5, Section 22B of the Constitution of Louisiana relative to judicial elections, to provide for election days for newly created judgeships and vacancies in the office of judge, and to specify an election for submission of the proposition of electors and provide a ballot proposition. The ballot language. Do you support an amendment to provide for the use of the earliest election date to fill judicial vacancies? In the 2024 redistricting special session, the legislature created a closed primary system for Congress, the Louisiana Supreme Court, and the State Board of Elementary and Secondary Education, the Bessie Board. Proponents of the amendment indicate that when the closed primaries start in 2026, and the way the law is currently written, it would be impossible to fill a vacancy. However, the Louisiana Supreme Court could appoint someone to fill that vacancy. A vacancy on the Supreme Court is so rare that a total rewrite of the Constitution impacting on 7 justice positions is unnecessary. When we created the second minority district on the Supreme Court, and when we elected to create closed primaries, legislators and the governor knew we would need additional elections. What should be done is to create a better process, giving the governor more flexibility in calling a special election once the Supreme Court has filled the vacancy on that bench. This was a lot of information that I shared, and I thank you for your time. Please remember to get out and vote on March 29th and vote no down ballot. If you have any further questions about any of the amendments that we just reviewed, please reach out to my office. The email address is hse099@legis.la.gov. And until then, thank you for your time, and I'll see you back at the tab. Thank you so much, Bishop Jefferson, for giving me this opportunity.